私人骨灰安置所條例草案喺度開始我哋呀。
All right, we have a quorum. The meeting is now called to order, and let us invite officials into the room. Well, you may now move on.
漂移啫，咪漂浮。呢個發展嗰度可能未夠，講咗發展先啦。開咗啦，我哋開咗啦。
We have already called the meeting to order. The meeting is now going on. We need one to stay on. Otherwise, we can't have our meeting.
等佢。我哋今日嘅會議係喺度搶。
Well, we are scrambling for members. We have 4 meetings going on in tandem, so our team will certainly be much smaller than the team of officials. At our previous meeting, we have studied the clauses one by one all the way to clause 96. The part that is to be studied will be presented by way of a PowerPoint. When will you make this PowerPoint presentation? I think this part is rather complicated. We want to give you a profile of this part. When you have an understanding of the general situation, then we will go over the details that will make the presentation or the progress of the study smoother. So I will let the administration to make an overall presentation on part 10 so as to facilitate our clause-by-clause study. So if I may give the time to the PAS, we are now in part 10. This is about the parts that will come into effect in the first 3 months. In the first 3 months, other departments can continue to enforce the law. We will speak on the provisions, and then we will speak on the overall concept, and then we'll speak on the logic of the framework. If you look at the provisions, Part 10 deals with implications on other ordinances. We've already briefed you on the bill. There will be strict requirements and conditions for the regulation of private Columbaria, and that includes or that covers pre-bill and post-bill Columbaria. With regard to pre-bill Columbaria, there are specified conditions and specified periods, and if the cases fall within the provisions of Part 10, other Cap 121, 123, Cap 31, and Cap 28, some of the provisions will have to be dealt with, and these provisions are related to the enforcement of the law. Will start with land, followed by town planning and buildings ordinance. Now, concerning the Director of Lands, according to Cap 28, Land Miscellaneous Provisions Ordinance, there are certain enforcement provisions that are applicable to the Columbaria. For such cases, say for example, if they are asking for a temporary suspension of liability, a license, or an exemption, some provisions, as I mentioned in Cap 28, will have to be suspended. I thank the legal advisor for giving us a letter on various issues, and the legal advisor has highlighted some major points. We will consider moving the relevant CSAs to amend the provisions. I will speak on the details when I come to those provisions later. some provisions are just suspended only. Now, if the applicant has not applied to the Lands Department for regularizing the occupation of unleased land, and if the a written declaration has not been made in respect of the right to recourse in respect of land, then law can be enforced. The law can be enforced. And when we review on Section 16, we've already said that if they have not done that, then they will not even have the chance to apply for a suspension of liability. And then the second part is in respect of the town planning ordinance. Under Cap 131, there are certain enforcement provisions, and we will speak on the details later. If they ask for exemption, a temporary suspension of liability, or an application for a license, then certain provisions will not apply for the time being. In considering such applications, the authorities will have to consider the following. If the planning authority has already taken enforcement action, say for example, a prosecution has been instigated, whether it is against the applicant or other people, if the notice has been served or if the prosecution has been started, and if they have not been withdrawn, then they will not be exempted. The authority can continue the law enforcement action. The third bit is in relation to the buildings authority, who has the power to enforce the law under Cap 123. Say, for example, if they are asking for exemptions or things like that. Now, if the notice or order, a notice or order has been served, and if the order or notice has not been observed or complied with and has not been withdrawn, and if it has been delivered or served on other bodies in respect of the premises, though not served directly on the applicant, then such an exemption will not be granted. Let me speak on the overall concept of Part 10. There are 5 major points which I want to spell out at the start. Part 10 spells out very clearly that it is for the purpose of implementing the bill. As for cases which have already breached the law, for example, in breach of Cap 28, 131, or Cap 123, then they are still breaches. The chairman has already said so. There are designated instruments or designated documents. Now, these cases, the liability has not been derogated or negated. We want to allow the Director of Lands, the Planning Authority, and the Building Authority to not apply certain enforcement provisions in respect of certain cases. The second point is that in Part 10, the first section is Section 96. The point is very clear. Now, a specified instrument does not to any extent negate liability to any description for any contravention of any other ordinance of law. Now, unless otherwise provided, subsection 2, 3, 4 apply.
In subsections 2, 3, and 4, they're about legal responsibilities. All these won't be affected. And number 2, concerning the requirements under this provision, they add instead of deleting or other legal requirements. And then in bracket 3, if we have some documents, then according to A, in relation to a specified instrument, it has effect solely for the purposes of this ordinance. B, does not to any extent negate liability of any description for any contravention of any other ordinance or law. And C, does not to any extent negate liability of any description arising under 1, 2, 3, 4. Number 1, an instrument affecting land, whether or not the government is a party to the instrument. 2, from an agreement, whether or not the government is a party to the agreement. 3, in tort, whether or not the tort is committed against the government. Or 4, in any other manner. Number 4, that any function is conferred on or performed by a person under this ordinance does not, to any extent, affect any function conferred on or performed by a person under any other ordinance or law. So we hope to bring up this important point right from the beginning. And then number 3, last time, Mr. Che Wei-chun made this point, saying that this approach is rather rare. He asked whether there were any precedents. In fact, it is not true that there isn't any precedent of this approach. There are strict requirements, and for example, some provisions will not apply for a temporary period. Actually, the LegCo had approved the arrangement that when the scale is small and when the intrinsic inherent risk is small, then before the 2nd of September 2013, if there are some unauthorized signboards, if the person had joined the buildings department's scheme, then in other words, there are professionals proving that these signboards are safe, and some construction works will have to be done so that the building authority will be convinced that everything is fine. Then he can benefit from this scheme. The relevant provisions are in number 39C bracket 1 and bracket 1A of Buildings Ordinance, Cap 123. There is a subsidiary legislation, Buildings Minor Works Regulations, Cap 123, subsidiary legislation, and number 62 and 62A. For this signboard system, well, it is promulgated under the law. As stated in the PPT, it is being endorsed by LegCo already. Number 4, in Part 10, well, under the stringent requirements and conditions, certain provisions won't apply, but there is a timing. When Part 10 comes into effect, if there is no application and when the conditions are met, the 3 law enforcement agencies can take law enforcement actions. And then under Part 10, if the prescribed period had expired, the 3 law enforcement agencies, according to their laws, can take legal actions. And C, concerning the not applicable provisions, they are only limited to the circumstances spelled out in number 97, 98, and 99. The law enforcement agencies, in relation to those provisions not spelled out, can continue to take law enforcement actions. Taking Cap 123 as an example, there are 24A, 26, and so on. The Buildings Authority can continue to take law enforcement actions. So, concerning Part 10, we're talking about only very limited scope of things of the provisions being not applicable. At the same time, there are some provisions in the ordinance in which we authorize the Director for Food and Environment, So he is given some law enforcement powers. He can enter some Columbaria and he can do inspection and checking to make sure that the specified instruments, all the conditions have been complied with. Besides, if there is doubt in certain cases of unlicensed operation, then we can apply for search warrant from the court. After getting the search warrant, we can also exercise powers under the search warrant, and then we can also arrest people who are suspected of contravening the law. And then we can also dispose of, remove, and forfeit certain articles. We can also issue notice to stop people from infringing the provisions or take remedial actions. If the notice is not complied with, this is a contravention of the law. If no remedial action is taken within a specified time period, the director can claim the relevant expenses from the relevant people. Well, these are actually in Part 6, and when we are on clause-by-clause examination, we will give further details. Overall speaking, everybody does agree that we should be very practical in handling Columbaria. Otherwise, disturbance will be caused to society. And now this approach has taken into consideration policy considerations in relation to land planning and buildings, and also actual circumstances about Columbaria. So this is a practical approach in handling this legacy. If members understand these 5 major points, then it will be very helpful for you to understand the provisions in Part 10. Okay, now let's move on to the sections. First of all, let's look at the framework. Okay, on the top, you can see Cap 28, 131, and 123. And the roles refer to the licenses, the exemption document, and also the document of exempting from legal responsibility. Okay, if you still remember, in applying for license, no matter whether we are talking about Columbaria before or after the bill, they have to comply with the town planning ordinance. So apart from Cap 28, you have to refer to the land grant. The person must have the right to use the land first. And if we read horizontally, there is the buildings ordinance. It actually covers the licenses, the exemption document, and also the temporary exemption from legal liability. It is a transitional period for them to have time to follow up. And if authorized persons can confirm that the building is structurally safe, and then some works are being done according to requirements, then we can consider. So for licenses, there shouldn't be any breach of Cap 28 and 131. If that's the case, then there won't be the question of the provisions being not applicable for a transient period. For buildings ordinance, actually there are detailed provisions for all 3 cases. And then the second row, exemption document. If town planning ordinance is not followed, well, there is the freezing and there won't be worsening of the situation. So there may be contradiction of the town planning ordinance. In LegCo brief, we want things to be regularized. So there wouldn't be the issue of contravention of the land ordinance. So in that case, there is not a need for the provisions to be temporarily not applicable. And then if you refer to the blue part, there may not be contravention. But if there is, other departments can enforce the law. So Part 10, the provisions being not applicable for a certain period of time, well, these may have to apply then. Okay, vertical. For the vertical column, for the red box, there may not be contravention. Then in the document to exempt from legal obligation for a temporary period, here please refer to the Land Miscellaneous Provisions Ordinance. Okay, Part 10, 97. We want to spell out the details. 6(1). If there is illegal occupation of land that has not been rented, then the Department of Land can post a notice. 6(2), if the notice is put up asking the person to stop, then the public officer can drive anybody on the land away and take possession of the properties or structures on the land. 6(3), according to 2B, if any properties or structures are being taken over, then they will become government properties, and they won't be subject to any restriction of rights of anybody. They can also remove or dispose of all those properties and structures. And then 97. Only under the following circumstances, Cap 28, 6(1), 2, and 3, during that period, will not apply to that occupation. And for that period, illegal occupation of ungranted land, we're talking about land related to the setting up of the Columbaria. And then if you refer to Section 97(1), okay, those provisions won't apply. But this is really necessary for the operating of the Columbaria before the bill. And then bracket 2 and 3 and 5. Under those circumstances, then there is the need of compliance. We will go through them one by one later. Because the licensing authority had imposed some conditions saying that the occupied land must not worsen in condition. So there are a number of barriers to handle this situation. If you refer to bracket 2, it means that for Columbaria before bill, if there is a document exempting from temporary legal obligation which is valid, then during this period, those provisions being not applicable will become valid. Number 2, if there is application from somebody, before application is made, now in the 4th to 6th month, there may be application. The person must make application as soon as possible. Otherwise, the other law enforcement agencies can continue to take law enforcement actions. If someone applies, then in relation to the Columbaria before bill, there must be this document to exempt from legal liability. And even though the application has been made, but then the licensing authority has not made a decision. That's the first timing we're talking about. Number 2, after the licensing authority has made a decision, if there is approval, then that's fine. All the specified instruments have been obtained. But then if the licensing authority declines, the applicant can appeal. Then what will happen? In the bill, according to 35, there will be a temporary excuse. But then after receiving the legal advisor's letter, the legal advisor has pointed out this point. So we're going to move CSA. In number 35, if you read the provision, when the applicant is in the process of making appeal, the licensing authority suspend a certain decision from operation. If there is no suspension, then the Columbaria may be suspended, and if the appeal is successful, then it is not meaningful.
According to individual circumstances, the licensing authority will make a decision. It may not be immediate enforcement, or it may not be immediate suspension. Now, there is a problem here because of this first application. With regard to suspension of enforcement, when you go to a court of a higher level, the application will only be made when interest is affected. Say if we are dealing with the application of a food license, the licensing authority has rejected or suspended or withdrawn or revoke a license, then the restaurant will have to stop its business. Now, then they will apply for suspension of this decision. But if there is no license, there is no regulation instrument, then there is no suspension. So the reference should not be towards Section 35. We will answer the letter of the legal advisor, and we will explain how we are going to move the CSAs. Let me now move on to the subparagraph 3 of this slide. We have. Well, I skip subparagraph 3, but I'll move on to subparagraph 4. I think it's subparagraph 4 is about planning. Well, I will address the point raised by legal advisor. If I may move on to subparagraph 5. And that is for the second phase for the suspension of or extension of legal liability. Suspension for the extension of. There is an application for the extension of a temporary suspension. If the extension is made or is applied for, and the licensing authority has not made a decision, so the provisions will be suspended. But if the application is rejected and there is an appeal, then according to Section 35, the licensing authority will make a decision to temporarily suspend the enforcement decision. As for subsection 6, now we have set out the conditions. There should not be any deterioration of unleased land. The conditions have to be complied with. Now, if the licensing authority has given the approval, the situation should not deteriorate. As for the time frame, and also the scope of unleased land, they must be necessary for ancillary to the operation of the pre-built columbarium. And it is the scope is as shown in the approved plans annexed to the temporary suspension of liability. And it is in respect of the announcement time of the bill. This is Section 97. If I may move on to subsection 7 and 8. In Section 28, or rather when we explain Cap 38, we said that there would be legal liabilities, say a fine and also imprisonment. The Director of Lands has two hats. he or she is the director or the authority. He or she is also landowner. As for unlawful occupation of unleased land, there is civil liability. So if the applicant has owed us money, then the applicant has owed us a sum of money, and that's the fact. Now we refer to 97.7, and you also have to understand that in 96 there is a general provision in which legal liabilities will not be affected. Now we have specified the special condition. 97.7 is a specified condition, and it does not affect the general provision of 96. That's subsection 7 and subsection 8. Let me now go back to subsection 4 of 97. If you may refer to the previous slide, the extension does not necessarily lead to a temporary suspension of liability. Now, this may be the first time. We will answer the legal advisor's point, said the Speaker. Our position is that unless there is no application for regularization, nor is there any giving up of right for adverse possession, we have to protect government land. If they have done the two steps, then means they have applied and they have signed to give up the right of adverse possession, then we will allow the temporary suspension of liability. If they don't do these two steps, then the Director of Lands can enforce the law. That is Section 97. If I may move on to Section 98 and 99. I think at the start you speak on the overall concept that is very useful. We know what you are speaking about. But when you come to Section 97, you refer to the Lands Department, the Land Miscellaneous Provisions Ordinance, and then you move on to the Planning Ordinance. Anyways, we have to go back to clause-by-clause study of the bill. Shall we, therefore, do clause-by-clause study since you have given an overall introduction? I know that you are very familiar with the provisions, but if you go along the present approach, then there may be repetitions. Okay, shall we start with Section 96? Okay, please move back to Part 10. Implications on Land Miscellaneous Provisions Ordinance, Town Planning Ordinance, Buildings Ordinance, and other ordinances. Section 96. Yes, the PAS. Please. Follow the order. Section 96. Other ordinances, law, and liabilities not affected unless expressly provided otherwise. Subsection 1. Subsections 2, 3, and 4 apply except as expressly provided to the contrary in this part. As for subsections 2, 3, 4, they are in relation to all liabilities and they still apply. Well, I'm happy to take questions in respect of subsection 1. Subsection 2. The requirements under this ordinance are in addition to and do not derogate from any requirement under any other ordinance of law. So this ordinance does not derogate any requirement under other ordinances. It will only add to. Subsection 3. Now, if a specified instrument is issued by the licensing authority, then under A, the instrument has effect solely for the purpose of implementing this ordinance. This is about the effectiveness or validity of the specified instruments. And then it goes on to say to speak about the implications on other laws. The specified instrument does not to any extent negate liability of any description for any contravention of any other ordinance or law. Subsection C. Now the above is about the law and ordinance. And C does not to any extent negate liability of any description arising from 1, 2, 3, and 4, and they are instruments affecting land, any agreement in tort or in any other manner. Subsection Roman 1 is in respect of instrument affecting land. Whether the government is a party to the instrument, the specified instrument will not negate any liability. Nor does it negate the liability in respect of any agreement, whether or not the government is a party to the agreement. And you can see that it covers other agreements, other instruments. It also, in respect of the liabilities arising in tort, whether the tort is committed against the government or not. And number 4 is a catch-all provision, the liability arising from in any other manner. So that's subsection 3. Let's stop here, pause here for a while, see if there is any question. Okay, none, move on, please. Subsection 4. That any function is conferred on or performed by a person under this ordinance does not to any extent affect any function conferred on or performed by a person under any other ordinance or law. In drafting Section 96, we have made reference to other laws. The coverage of our provision is wider than other ordinances. It is more comprehensive than other ordinances. Any questions on paragraph 96 or Section 96? In fact, the PAS has already explained that. Section 97, please. Now the effect is about the effect of land miscellaneous revisions ordinance modified. That is cap 28. Under subsection 1, there are 2 conditions. Section 61, 2, and 3 of cap 28 does not apply in respect of the lawful occupation of unleased land during a period. I will speak on the period later. And the 2 conditions are A and B. The occupation is necessary for or ancillary to the operation of the prebuilt Columbaria. That means the applicant cannot just broadly say that all unleased land will be covered by this application. It must be necessary and for and or ancillary to the operation of the prebuilt Columbaria. Now there is a paper listing the related provisions of cap 28, and they are, you may refer to this, 6.3, Land Miscellaneous Revisions Ordinance. 6.3 refers to 2B. Does it mean that 2B is not covered? Yes, I think the legal advisor, 2B is not covered. Cap 28 is 6 cap 1, 6, or 6, 1, 6, 2, and then 6, 2A, and then 6, 2B, and then 6, 3. 6, 2A deals with structures being built or under the construction process, or the built structures are not habitually or bona fide used. Under such circumstances, the director doesn't need to put up a notice and he can take action. As for 6.3 of Cap 28, 6.3 said that these property or structures in respect of 2A and 2B. Since 2A is not included in Section 97, the Director of Lands can exercise the law under 2A.
So this is not covered in 97. So we're going to move an amendment to clearly state that About 6 bracket 3, concerning 6 bracket 2A and 3, they are not included. Only bracket 2 will be covered. Mr. Wong? Mr. Wong Yuk-man? In B, 1 bracket B, that particular period, and Roman number 2, that period, that particular period. So I want to know the period as compared to period mentioned in bracket 2. Are we talking about the same period? Yes, thank you, Chairman and Member. In 97, well, there are subsections 2, 3, and 5, and there are different time periods. On, for example, the exemption of legal liability documents and appeal and the extension and so on. So it depends on whether we're talking about 2, 3, and 5. That period is the period spelled out in the relevant provision. It's difficult to understand. Occupation during that period. In number 6 bracket 1, 2, and 3 of the Land Miscellaneous Provisions Ordinance. So these does not apply in respect of the unlawful occupation of unleased land during a period. Well, I really don't understand. There is during a period, and then 1 and 2, and then during the period again. B, during the period, and then there are 2 items under that. So these 2 Roman numbers 1 and 2 will apply during the period, right? Yes, there are different circumstances in relation to the relevant provisions. So there's the use of the period. And during different periods, the occupation of land may be different. So that's why these conditions have to be qualified this way. What will be the differences? Now, in the temporary exemption of legal obligation, based on the circumstances observed at that time, there may be more cases. Okay, there are application for licenses, application for exemption, application to the lands department. So there may be additions and subtractions. Unlawful occupation of land will be narrowed. During temporary exemption of legal liability, the occupation of land, the scope may differ. So during different periods, we have to look at the different occupation. In the English version, there is no repetition, right? Yes, I understand. No, you don't know what I am talking about. Okay. In the English version, during the period. During the period. Does not apply to the occupation of land during the period, and then 6 bracket 1, 2, and 3, right? So it won't apply to that occupation during that particular period. I don't understand. If I don't understand, then people reading the law won't be able to understand it. When we go back, we can review the wording. I understand your point. Do you understand it yourself? You are not answering my question clearly. I think things have to be clear and certain. Yes, I understand that it is difficult to translate English into Chinese. Any in English, and you just translate it directly. In fact, you can change to another phrase. It is not right to use 6 任何 in number 96. But then this is really confusing. What is the difference between during this period and during the period? There is not such difference in the English version. In the English version, during a period, right? A and B, and then B during the period. If we read the Chinese version, it won't apply during that period. It's equal to, in number 1 in the English version, during a period. Yes, I agree. A, during a period. If we read the Chinese version of A, and the English version, Chairman, let's not waste time here. Just ask them to amend it and fine-tune it. The English version is very clear. B, during the period. In number 2, there isn't during the period again, right? Yes. But in A, the English and Chinese versions are different. Section 6, bracket 1, 2, 3. Is there this mentioning? Sorry. The ordering in Chinese and English versions are different. In the English version, there is during a period at the beginning, but in the Chinese version, during a period is at the end. So that's why there is this phrase. Perhaps member is right. There are too many repetitions of the same phrase in the Chinese version. Well, I believe that there isn't any difference in your meaning. It's a matter of fine-tuning the language so that people may interpret 該期間的 and 該期間內 differently. Right, I think our colleague is right. But can we simplify things? Cannot apply to that occupation. Is that okay? Basically, I think the meaning is understandable. Yes. We will go back to check. Any other questions? Law draftsman? Any supplement, Ms. Cole? We can go back and re-examine it. Okay. Next. If there is this temporary suspension of liability instrument, if it is in force, then the provisions mentioned just now will not apply temporarily. Instrument-related, there is the temporary suspension of liability instrument. I think this clause doesn't sound right. If Columbarium has or holds temporary suspension of liability instrument before the bill, then ... I think that will be much better. Okay, we can cross-check the English and Chinese version. If a temporary suspension of liability is in force in respect of the pre-bill Columbarium. Can you explain this? I think the Chinese is really unacceptable. That's because of the translation arrangement. But this is not right. There's a comma here. You usually don't like to use comma. There are a number of phrases here. Altogether, there are 20, 30 characters. Well, those who have asthma won't be able to read it at one go. The instrument-related condition is met if a temporary suspension of liability is in force in respect of the pre-bill Columbarium. Okay, is there any difference in my suggestion and your drafting? That's just my example. You can change it yourself. B bracket 1. That condition would be met if there is the temporary suspension of liability. Only for pre-bill Columbaria will this apply. Okay, I think you have to break the sentence at least. Ms. Lemay Fan. In 1991 till now, we have been arguing many times when I was sitting in the Commercial Law Committee. And then, yes, we have discussed this for a long time. We can't understand your Chinese version. There have been these translation problems all along, and it is not understandable to ordinary people. 屬或符合, I think this sounds odd. So with the temporary suspension, then the conditions can be met, right? In drafting law in English, passive voice is usually used, but if you translate it directly into Chinese, then it is very long-winded. 即屬或符合. It is really odd. It is really strange. You're using passive voice. In English, passive voice is preferred, but then in Chinese, I think you can spell out the meaning directly. If the conditions are met, that's good enough. 即屬或符合. That is really strange. Yes, I think you should listen to us. Okay, this is about the text. Okay, number 3. If an application is made, but the application is not determined yet, in A, the licensing authority has not made a decision yet, then during this period, okay, there will be bracket number 1, bracket 2. The licensing authority has made a decision. If the decision is an approval, then no problem. There is not the need to refer to these provisions because that will be the instrument. But if the licensing authority turns down the application and then the applicant appeals against the decision, now we are going to amend number 35. When the appeal is yet to be determined by the appeals board, then there is a precondition. Before the application was made, they're already applying for the regularization. At the same time, there's a written declaration saying that there is no right to make a claim on the land. Any questions? No? 即屬或符合. There is still this Chinese phrase. Okay, I think you can also reconsider. Today, 2 bills committees are meeting at the same time. We cannot examine all of them at one go. Can we make a general suggestion for you to fine-tune the Chinese? This is just the tip of the iceberg. I think you should review the Chinese version and make sure that you can spell out the meaning directly. Make sure that it is really understandable by ordinary people. If you ask them to review, I think they will, they may do it in the same way, in their own way. If you find problems, please raise them because the writer may think differently from the reader. The writer will follow his own logic. Chairman, this is my suggestion. Yes, the writer himself may find it understandable because he just translates directly. But then we are making a very important bill. Can you find a third person to check? I think all the criticisms made are very constructive. Okay? So a third party, your colleague, someone who is good at Chinese should check. Please don't read the English version. Just read the Chinese version and see if things are understandable. Well, I think the meaning can be obtained, but then maybe people will fall asleep when reading the clauses. Number 4, in bracket 3b, okay, if there is the appeal and the appeal is not determined yet, we said just now that there is a precondition. So 4, bracket 4 will also be changed. It's not about the notice. When the applicant makes application, he has not submitted the application to the Lands Department, and he has not made a written declaration saying that he does not have the right to claim on the land, then in that case, the Lands Department, under Cap 28, can continue to take law enforcement actions. Okay. Bracket 5. It is about the extension of a temporary suspension of liability. An application has been made. A, the application has been made to the licensing authority, but no decision has been made yet. And in B, the decision has been made, but the application will be refused, and then the applicant is going to make an appeal.
Unlike at the juncture of the first issue, the licensing authority will decide on whether there will be suspension of enforcement. It doesn't mean that for each and every case of appeal there will be suspension of enforcement. Is it okay here? If not, then we move on. Subsection 6. Now we have taken a snapshot. The licensing committee, in making in considering the application, will also drawn up the boundaries of the unleased land which has been occupied. They have to comply with the no worse than before situation. After a suspension of document has been issued, then the area will have to be in relation to the operation of the ancillary to the operation. Now A, that is about issue a temporary suspension liability has been issued. But if it has not been issued, then it will be based on the cut-off time. Any questions from members? No? Then please move on. Item 7, or rather subsection 7. Now I refer to CAP 28, 6263. There are criminal liabilities. We say that the criminal liability doesn't apply or is suspended. But it doesn't mean that we will not go after the offender for civil liability. In the future, after they have regularized this, now if they have regularized the Columbarium, they've paid the money, pay all of the money to the government, then the civil liability will be absolved. If the money is not paid, then what? Even if approval has been given, yes, we will follow that up. If it is a license, a land license, then the lands department will have to receive the money and regularize the land. And the license or exemption will only be issued after the land has been regularized. Now, say the regularization is not successful, we can still recover the money. The application may fail. Any questions? Right. Subsection 8, you have spoken on that already. Yes, Kenneth Chan. Now, they move on to the town planning ordinance. Now, in terms of policy, the government wants to provide adequate Columbarian niches to Hong Kong. So the administration is going to find a balance. Now, there is a concern, and that is you let the operators off the hook. Now, the law enforcement departments will continue to enforce the law, retain the power to enforce the law, and your so-called adaptation or adjustment will not undermine the enforcement of the law. Say at the start, you say that if they are unleashed land occupied, unleashed land, they must be ancillary and necessary to the operation. It is up to them to say whether it is or not. And then they apply for the temporary suspension of liability to protect themselves. They have several levels of protection. Does it mean that the government departments will gradually allow that even if it is unleased government land, it has been occupied, and they will just let the operator off the hook? Now you say you suspend the enforcement of the law and you say you will claim civil liability, but later you try to consider the application. So Does it mean that generally you were going to allow them? Now, we know that's not the situation, not the case. Now, we give them time to apply, to regularize. And then we have already frozen it in 2016, the 16th of June. They have to apply to the Lands Department for regularization, whether it's a license or an exemption or waiver. And then we will deal with it through this process. How do you decide whether the occupied unleased land is necessary? And it's up to the licensing committee. No, the licensing board. The licensing board will decide on that. I think the so-called adjustment or adaptation is that what they are doing is illegal. And then they will be given a period of time to deal with this. And then by making use of this law, the Lands Department or the Planning Department or there is one more, right? Yes, the Lands Department will tolerate this for the time being. My question is, if they can regularize that, they can make changes, that's okay. But if they cannot make the change, then will the civil liability still stand? Yes, indeed. Even if they failed in the application, they have the civil liability. Now, this change here is for that period of time. They will be lawful for the time being. Now, you cannot say that they are lawful. They are allowed to maintain the status quo. In fact, it's a breach. It is a development on unleased land. Well, Chairman, I don't think that's right to say that it is temporarily lawful. No. It is unauthorized building works, even if it has been regularized, it's still unauthorized. Unless they have regularized that. They have been given a permit. Have you set a time period for that? It was said that no more than 3 years. No more than 3 years, and the extension is also no more than 3 years. All right, we move on to Section 98. That's adapting or modifying, rather, the Town Planning Ordinance. Yes, we move on to Section 98. Section 98. Before I go into Section 98, please refer to this table. Whether it's pre-bill or post-bill, they have to comply with the Town Planning Ordinance. When the exemption, they may breach the exemption or the temporary suspension instrument. Well, let me first speak on Cap 131, which the bill refers to. They are Section 28, 21.2, 23.1, and 2 of the Town Planning Ordinance. 2008 is in respect of a DPA, Development Permitted Area. That is that's in respect of drawing or plans, DPA plans under sections 20, bracket 8, 21.2, and 23.1 and 23.2. No development is allowed unless it is an existing use. Number 2, unless it is obtained approval. Under Section 16 of the Town Planning Ordinance. This is in breach of this is an offense, and the planning authority can take prosecution action against such breaches or offenses. 21.2 says that if there is a DPA plan, then no one is allowed to proceed with or conduct any development unless it is an existing use or unless it is in line with the DPA plan and or the development or continuing development has already been approved under Section 16 of Town Planning Ordinance. Otherwise, it is an offence. The planning authority can take prosecution action against such acts. The conditions are similar to 21(3). That is either is existing use or it is it falls in line with the DPA plan or it has got an approval under Section 16. And then is 23(1). If there is an offence, then the occupier or owner or the person responsible will be sent a notice or delivered a notice. And in the notice, there can be items that there can be specifications on items which are in breach of the law, and the breach has to be suspended. Otherwise, prosecution can be taken out. Under 23(2), if the authority is of the view that there is unauthorized development and if it is continued, it may cause A, health and hygiene hazards, or C, B, adverse impact on the environment, or reinstatement is not practicable or not in line with not economical, then according to the notice under 23(1), the authority can appoint an earlier date before the date of termination, and on or before that date, steps have to be taken to prevent any matters causing such impacts, and the director, or rather the planning authority, can take prosecution action. All right, we may now refer to Section 90. We may now go back to Section 98. Section 98, subsection 1. The four provisions I mentioned under Cap 131 do not apply in respect of an unauthorized development undertaken or continued on any land during a period if conditions A and B are fulfilled. Condition A, the development is necessary for or ancillary to the operation of a pre-built columbarium. Just like the previous section in respect of land. As for the condition B, it is during the period. During the period means upon the issue, when the suspension of liability is issued, or when the extent of unlawful occupation of leased land was the bill of announcement. Chairman, I don't know whether we've already passed Section 98. Are we on Section 90? Have we passed Section 97? Yes, indeed, we have. What is your view on Section 97? Chairman, I've stressed many times that the implementation of the law has to be done in tandem with government departments, other government departments, procedures and measures. Say, what are the basis for accepting the application as far as the lands department is concerned? Have you, or other departments, have you consulted all the departments and there is a package? Now, there are specific provisions in respect of the modification. Yes, I understand that they are in the law. As for each application, it is to be dealt with according to individual circumstances. No. It is in respect of the Land Miscellaneous Provisions Ordinance, Cap 28, 6(1), 6(2), and 6(3). There are modifications. That's for lands. As for planning, town planning, is Cap 131, Section bracket 20, bracket 8, 20, bracket 2, 23, bracket 1, and bracket 2. There are modifications. and that these do not include what you say.
This is to enable them to continue to enforce the law. Okay, this is being said, but concerning the administrative procedures in the government, are they in line with the whole practice? Well, we are in close connection and liaison with the lands department. If it is private land, if there is breach, they have to make application. And concerning the license, the licensing conditions are to be met. They have to pay premium or make relevant payments. In the case of exemption, in the LegCo brief, we have made the point already. We're not saying that they will definitely do it, but they can consider how to make the payment. You are talking about the principle. Okay, I am referring to what will they do in the cases of A, B, and C. Has the lands department explained to you that they will implement things accordingly, and they have the adequate amount of manpower and resources to do it? If the bill is passed, well, would that be the situation where the other departments do not have the manpower and resources to do all these? Then at the end of the day, the law will become futile. We have discussed this for a long time. Right, on this part, has the lands department replied to you in writing that they have the ability to do all these? Please don't resort to principles and concepts. Thank you. We understand members' question. Before the commencement of the law, we will strive for resources to make sure that all the departments which need additional manpower because of this law, we will strive for the additional manpower for them. This is definitely going to be done. What will be done under A, B, and C? We are still liaising with the lands department. But we hope that there will be a clear approach for everybody to follow. And at appropriate time, we will give further information. Chairman, I won't repeat the same question. I hope the Secretary can help. Before this bill is tabled in LegCo, I hope that there should be complete reply on all these queries. So it will be better to have that paper when this bill is presented for second reading debate and third reading. Yes, this point had been discussed many times. Mr. Chan had raised this for 2-3 times. Well, Chairman, my feeling and my understanding is that this is really not feasible. Yes, let's wait for the government's reply. We won't give up because this is an actual issue. We have to make sure that things can really be implemented. If it is only empty law, it's meaningless. Okay, let's look at bracket 2. When we were on section 97, well, in 97 there's only the temporary suspension of legal liability, and then here, when there are these specified instruments and when they are in force, then the conditions are met. Number one, the exemption instrument, and number 2, the temporary suspension of the law. No problem. Bracket 3. When an application is made, and then the licensing authority has not made a decision yet, or a decision is made but the application is refused, then the applicant is making an appeal. According to the legal advisor's view, we will move CSA to make an amendment. We have already introduced the proposed amendment just now. We won't repeat the point. Okay, bracket 4. If you still remember, at the beginning, when we talked about the application of the specified instrument, okay, concerning the unauthorized development, for example, legal proceedings had started, then we won't accept the application. So this is really the same thing. If there is this situation in para 3, okay, the application will not be taken in, then bracket 1 will not apply. Before making application for the specified instrument, then the legal proceeding, if the legal proceedings has started already, or if the notice has been delivered or served, the notice had not been revocated, then bracket 3 won't apply. Then the power will not be affected. No question. Number 4. Number 4 is concerning renewal. When the temporary suspension of liability, well, if this is an application for extension, and during the period when a renewal of the exemption is applied for, if the licensing authority has not made a decision, that's in A. B, if the decision is a refusal, then an appeal will be made. Because it is in the extension period, then we'll see whether the licensing authority may suspend the operation of the decision. Please continue. Okay. Buildings Ordinance 99, Section 99. Again, let's refer back to this table. No matter whether we are talking about the exemption and temporary suspension of liability, well, if there are any inconsistencies, we will work according to the law. If there must be authorized persons to prove that it is structurally safe, and the necessary engineering works will have to be carried out. When application is made in the case of temporary suspension of liability, there must be a certificate issued by the professionals to confirm that in terms of building safety and fire safety, there won't be imminent danger. Before moving on to Section 99, in Cap 1, 2, and 3, what are the relevant provisions about? 24 bracket 1, 24C bracket 1, these won't apply. What are these provisions about? 24 bracket 1. If there are any breaches of any provisions in the buildings ordinance, or if it is a building, a construction works or a street works, then the building authority can demand in writing that the structure or the construction, the street works have to be removed, or there must be modifications to make sure that provisions of the buildings ordinance can be complied with, or to stop the breach of the buildings ordinance. Concerning the required alteration, modification, and demolition, the deadline must also be specified. We are talking about 14 bracket 1, not all provisions. According to 24 bracket 1, all provisions of Cap 1, 2, 3, well, orders can be issued. Later on, we will explain further that we are only targeting at Cap 1, 2, 3, 14 bracket 1, and not others. According to 24, well, it can be issued for other ordinances or provisions as well. 24C bracket 1. If there is any breach of the buildings ordinance, if it is a building or construction work, then the building authority can issue written notice. It's not an order, stating that before a certain date, the building and the construction works are not being demolished or modified before that date to make things in compliance with the ordinance. then that notice will be registered with the land registry. In other words, by doing a land search, people will know that the building or or that particular structure is against 24C1. Then you may ask about 24(1) and 24C1. What's the difference between the two? In 24(1), if you read the audit report, the most recent audit report, the UBWs will have to be demolished first, and then in 24C(1), we're not talking about UBWs with priority. 24C1 will not prejudice against 24(1). So in other words, 24C(1) can still be used about issuing orders. Okay, then let's move on to clause 99 or section 99. What about 14(1)? 14(1), will you explain? Cap 123 Buildings Ordinance 14(1). You want to know what that provision is about before carrying out any works. An application has to be made to the Buildings Authority for approval, and when commencing a certain work, his consent has to be obtained. Mr. Albert Chan, are we on 99(1)? Yes, bracket 1, because 99 is about Buildings Ordinance Cap 1, 2, and 3. Cap 1, 2, 3. So actually, if you refer to the PowerPoint slides, 24(1), 24C(1), well, they are about section 14(1) of the Buildings Ordinance. Okay, about exemption. 24(1) and 24C(1), we know what they are about specifically. Yes, we just covered that. What about fire safety? Are they included here? In the Buildings Ordinance, there are also some appendices about fire safety. The Buildings Department has their priorities. If there is imminent danger, immediate actions will be taken. There are a number of ordinances and related parts. If they are to continue, then the law will have to be altered or suspended. So there will be this contingency under certain circumstances. So only under these few sections. Okay, just now we're on the Town Planning Ordinance, and previously we're talking about the Land Miscellaneous Provisions Ordinance. Only these allow contingencies. Okay, if you refer to C of main point 4, 99, section 99 is on cap 123 14(1). So no prior application had been made to the building authority, and construction starts without his approval. And then cap 123 of Buildings Ordinance contains a series of provisions. If we're talking about construction works or street works that may cause imminent danger, there's 24A. So law enforcement actions can be taken. Okay, can you explain in layman terms what this exemption is all about, please? 14(1). In bracket 1, the point is made. So, which is what? I think you can read this table. Yes, I am on it. I don't have enough time to digest everything. There are 3 meetings for me today. Can you please explain in more straightforward terms? So in order to carry out some works, prior application for approval has to be made to the Buildings Authority. And when people commence the construction works, again, approval has to be given by Buildings Authority. Okay, so we're talking about new construction works. We're not talking about problems in existing construction.
It is not related to the breaches. Where they have not applied for approvals, and they have conducted the works. Can I give me a minute? Maybe the AD can explain this. Let me try. Under the Buildings Ordinance, there is a requirement. If you want to put up a structure, you have to get prior approval. You have to get the prior approval for works. And there is 24(1). If it is an UBW, simply because you have not obtained approval, there will be a clearance order. There is a policy under this. In this order provision, the modification is this: the pre-columbarium. If a pre-columbarium complies with certain conditions, then even without our prior approval, they will not be subject to law enforcement. Even if it is illegal, it's illegal. It's just that they will not be dealt with for the time being. They will be allowed to exist. If they have 24(1), 24(c)(1), then there will be no enforcement. No enforcement for the time being, yes, to put it simply. 24(1), 24(c)(1) do not relate to imminent danger or breach of fire safety requirements. That will be according to other ordinances. Say they may involve the means of escape, the breach of the means of escape requirement. That is not related to the modification. If it's in breach of fire safety, just for this reason, it will be required to fold up. The fire services will take law enforcement action. The simple answer is the affirmative. Yes. If there is a fire hazard, it will be dealt with by another ordinance, Cap 95. We do liaise with the fire services. Now, there is a period of 6 years. It's a long period of exemption, and we therefore need to be very careful. Safety is our concern. There must be no obvious and imminent danger. Cap 95 applies. If there is a fire abatement notice, that it will continue. If there is blocking of means of escape, then law can be enforced against the operator. What about burning incense? If the licensing mechanism deals with safety. Now, as for pre-Columbaria, they are in breach of our policy. If a license is given to them, that is in breach of the law, and therefore we need the modification. I just want to know the scope of the exemption. I want to make sure that it's safe. The safety will not be affected because of exemption. Absolutely not. The bill has already dealt with safety. Okay. Next provision. We are now on Section 99(1). I do not repeat. They are similar. During a period, during that period, the structure necessary for or ancillary to operation, they also have to comply with conditions 2, 3, and 5. It's similar to previous sections 97, 98. It specifically deals with Section 24(1) and 24(c)(1). They are the orders and notices under these two provisions. Now, the exemption may be for 6 years, 3 + 3, right? Yes. Yes, indeed. So a period of 6 years at most. Once an exemption is given, it may be very dangerous. As already explained by Mr. Yu, the suspension of liability is based on no imminent and obvious danger. if it is an exemption or a license, first of all, in getting that, first of all, they have to get an authorized person to prove that it's structurally safe, and they also need to comply with certain conditions. For example, reinforcing the structures. And within a certain period of time, they will have to provide certificates that they are safe. There are different conditions to ensure safety. We will not compromise safety. It is not a 6-year period. Now, during the modification period, fire safety conditions have to be complied with. So there is, it's not a question of 2 or 3 years or how many years as far as fire safety is concerned. You have to comply with fire safety. And you also have to deal with the unlawful structures. You only deal with the unlawful structures. You are not dealing with dangerous buildings. Is my understanding correct? Yes. Yes. Subsection 2. They are the 3 instruments: license, an exemption, or suspension of liability. Within that period, the provisions under subsection 1 do not apply. Is there a question, legal advisor? The license may not be for 6 years. Your grace period may be more than 6 years. Yes, indeed. If it is a suspension, then it is 6 years, but the license or the exemption may be more than 6 years. Subsection 3. If an application has been made and before a decision has been made by the licensing committee, or the licensing committee has rejected the application and an appeal has been made, as we said in previous applications, according to legal advisor, we will move CSAs to deal with this. Subsection 4 spells out the conditions which subsection 3 does not apply. The authorities, the power of the building authority will not be undermined. Say under section 24(1) or 20C4(1), orders or notices have been served and they have not been complied with, nor have they been withdrawn. Then subsection 3 does not apply. And that means the building's authority can continue to enforce the law. Subsection 5 is about extension. In respect of the specified instrument, a further application has been made for renewal or for extension, and the licensing authority has not yet made a determination or has refused the application, and the refusal is appealed against. Then the licensing board will decide on whether the decision will be suspended. Subsection 6 deals with the breach. The breach has to be limited to the time frame we set. The UBWs have to be necessary and ancillary to the operation of the prepared columbarium. And if a specified instrument has been issued, it is in respect of the approved plan that we mark out the structures. If an application has been made and no decision has been made, and then we will base on the snapshot. That is at the date of the announcement of the bill. Yes, legal advisor. In section 99(4), reference is made to 24C1 of the Buildings Ordinance. But in 12(3)(b), there is no reference to 24C1. What's the reasons for that? That's a good question. when we spoke on Section 22, if law enforcement action has been taken, then the enforcement action will continue. We will not entertain the application for specified instrument. But if you refer to 34193B, we will only refer to 24(1). That is in respect of the priority targets. They are the orders against the priority targets. If these orders have been issued, we will not allow them, will not entertain the application. As for 24C1, it's a bit different. Generally speaking, it is not the priority buildings or priority structures. If you look at the audit report with regard to Section 24, they can make an entry in the land registry, and enforcement action can be taken. As for 24C1, it's only making an entry with the lands registry. Or when people do the search, they know that there is an encumbrance attached. In respect of breaching 24C1, we want to force the owner to rectify the breach. Otherwise, you will have difficulties in conveyancing. Now, we need to strike a balance. If there is a 24C1 notice, we may not reject the application of hand. Therefore, you can see that we do not include 24C1 under 12.3. But when it comes to enforcement of the law, if there is 24C1 notice, we can still make an entry in the land registry. We can force him to regularize the land, and then we can take away the registration, or we can take away the entry. If you look at 99, Section 99, we have included 24C1. And that is, there will be temporary suspension of enforcement, or temporary suspension of liability. We are lenient for accepting those who come forward to make an application. But if they have 24C1, then we'll force them to regularize the matter under 24C1. Where you allow people to come in more leniently, but when you deal with the case specifically, you also have to deal with 24C1. If 24C1 has been issued, you will have to deal with it. Yes, after if they want to get the specified instrument, then they will have to regularize it. Okay, no question, move on. Section 100. Section 100 deals with provisions inapplicable because of Section 97, 98, or 99 to resume application. Even if because of the operation of the above sections, the section does not apply in respect of a pre-bill columbarium during a specified period, but that fact does not in any way affect the application of the provision in respect of the columbarium after the period. Say after the expiry of the specified instrument, then the three law enforcement agencies can resume the enforcement action. Okay. Subsection 2. Subsection 2 refers to subsection 1. The specified period means period during which the conditions referred to in section 97.1, 98.1, and 99.1, and only those periods. Now, after the period, law enforcement resumes. The addition of subsection 3 is subject to subsection 1 of section 96.
So concerning the general principles and circumstances in 96, those will not be affected. Any questions? No questions? Okay. These are the provisions in Part 10. Okay, we have just gone through them once. All right. Thank you. Today, we have gone through the modifications in Part 10. So the law is still in effect, and then, but then during implementation, they won't come into operation, and some room will be left for them to tidy up things. So these are about land, town planning, and buildings. Okay, on the 18th of June, since 18th of June last year, some pictures have been taken. Is it true that on all these sites you have got some information about these 3 ordinances? When the law takes effect, the departments will already be prepared, and then for the private Columbaria, some of them may not be in line with the legal requirements, so they will fall into bracket 24 bracket 1, 24C bracket 1. Do we have a table to cross-check, or you will just wish everybody good luck? So there are essential facilities in private Columbaria. Some may be occupying government land, some may not have made application, and so on. So among government departments, do you have this information or data to facilitate future law enforcement and to help the licensing authority to deal with all these instruments and applications? Now, we have got some information in the notification mechanism. We have marked all the action remains and also the supporting facilities. We have taken pictures, we have made markings. So concerning the government lands being occupied and also the structures, we do have information because the quantity is huge. And we are still sorting out places of burial or of storing the remains and the ashes. And in tables 1 and 2, concerning breaches of town planning and lands ordinance, there's updating once every 3 months. So the database is consistent with the actual condition. The buildings department had done a field survey. So when it comes to the type of structures, you can see that we have written down how we are going to handle the structures based on their types. So these are based on the field survey. And with the notification mechanism, we can seize more accurate information. Now we still haven't shared the information with other departments. After the bill is passed, we can work with the other departments. Information can be circulated among them. Right now, we may not be able to do any cross-matching, but then we do have the information. During this process, now the bill has not come into effect yet, so the existing ordinance can still be enforced in handling the regularization applications. Okay, if people want to make application to normalize their operations, then what are your considerations? This morning we talked about a case. The cutoff date is 18th June 2014. If these already existed before the cutoff date, then they would be incorporated in the application. If they exist after the cutoff date, unless if they are made good, if they have got the approval from the buildings authority, then they can make application. But, well, because they exist after the cut-off date, then they are not in line with our definition of unauthorized building structures. Let's say at 8 a.m. on the 18th of June, you took pictures or you received their information, so that was a snapshot. Then there might be, for example, toilets or washing basins and so on, other facilities being added after that. Then they asked your colleagues to reconfirm the legality of these additional facilities. When the bill was being scrutinized, the departments are of the view that these facilities like toilets and washing basins are really essential. So will this happen? Even after the bill is passed, normalization application can still be made. Concerning the building structures, we're talking about the licensing authority considering whether they should be covered in the regulation, and there will be a cut-off date. If these facilities existed before the cut-off date, then they would be considered. If it is behind or after the cut-off date, they will have to talk to the buildings authority. If they haven't applied according to 14.1, then those will be UBWs. The licensing authority will not consider them. What people will have to do will have to apply for approval under 14.1 so that there will be approval. Okay, the question is straightforward. Now, in 2014, now there are things after the 18th of June 2014. Will other government departments like the Buildings Department, Planning Department and the Lands Department give approval to new structures being added to the Columbaria? That's the question, very straightforward. Deputy Secretary, Chairman, for structures being added after the cut-off date, if they are against the law, then they cannot enjoy all the modification provisions that we discussed today. So there may be the possibility, but they cannot enjoy all these modifications. Okay, to put it simply, if there is no advanced application, if they would like to get the Buildings Department's approval, they have to follow all the rules. For example, they may have to dismantle the structures first. There won't be the contingencies. Okay, so they should either take care of them or they won't enjoy the modifications. So it's a yes or no issue. Either black or white. You should either first get the approval, otherwise not okay. So there is still the possibility of adding some facilities to get approval. And they should consult the licensing authority. But the licensing authority will only focus on the conditions before, right? Concerning the modification provisions, we will refer to the snapshot before the cut-off date. Any new things like new applications on a new site, things that we haven't seen before, then they have to follow all the provisions as they are without modifications. Chairman, for residents greatly affected by the unauthorized Columbaria, they are very worried. I don't think you mean that you don't know. Well, I think it is not 100% right to say that the bill will lead to 100% freeze. Well, there may be the possibility, but there will be the approval. Yes, they have to make sure that all the requirements are met. We have to look at the situation before, and with the modifications we can deal with those that existed before. Is my understanding correct? Yes. Yes. Okay, if that's the case, then we will conclude our discussion on part 10. Now we should go back to 3386, part 1, page 3386. Okay, we have completed the first clause. Now let's move on to clause 2. Well, it's already 4:25 now. I don't think I will start the scrutiny of clause 2. So next time we will start from page C3388, right? Okay, so we'll start from clause 2. That's on interpretation, right? Next. Okay, if there is no question, then any other business? No? Then I would like to remind you that our next meeting will be on the 11th of June, Thursday, 8:30 a.m. Okay, so we will meet at that time. Now I declare that this meeting is closed here. Thank you.